Hey, good afternoon. This is Doug Field, the Chief Growth Officer with Verify Analytics, and welcome to today's webinar entitled Retirement Plan Fixer-Upper, a case study for plan sponsor fiduciaries. We sincerely appreciate you all joining us today. For those of you who are back with us after being with our first webinar, thank you. For all the new participants, welcome today. I just want to remind you that this webinar will be recorded and you will receive a copy afterwards. Also, we'll have a Q&A period for about 10 minutes at the end of this webinar. Our two key speakers today are Ann Tyler Hall with Hall Benefits and Al Otto, the CEO of Verify Analytics. Ann, prior to forming Hall Benefits Law, practiced ERISA and employee benefits law with Alston Bird and King & Spalding. Ann brings her passion for helping businesses to her practice of ERISA law, and she enjoys leading her team to help clients meeting their benefit goals. Ann Tyler Hall built the firm knowing attorneys must partner with clients to understand their goals before serving as effective counselor. Ann is a 2017 and 2018 Georgia Super Lawyers Rising Star with Martindale Hubbell AV Preeminent Rating, and she has received the Martindale 5-star reviews from both peers and clients. Do you get glassy-eyed when someone starts talking about fees and funds? Or have you ever wanted to just run when you hear the F word? And of course, we're talking about the word fiduciary. Well, today's speaker with Ann is Al Otto, who is known for making these things simple. He is an author, thought leader, and federally recognized expert on 401k fees and fiduciary matters. And currently is the CEO of Verify Analytics, a fintech company dedicated to measuring the value added to retirement plans and delivering objective plan outcomes feedback to plan sponsors and those who serve them. Please welcome Ann and Al. Al?
Hey, well, it's great to be here. And Ann, always great to spend a little time together.
Absolutely.
This is awesome.
Issues near and dear to our hearts.
That's right. We're actually going to talk today about a retirement plan that we worked on together. And I was hired to do an assessment and review this plan. And so I always get excited about that because you never know exactly what you're going to find. But as I started to dig in to this plan, I realized very quickly that it needed legal counsel.
Yes.
Because the issues were huge. And so it was a very interesting conversation with the president of this company when I called him back and said, well, okay, you're sitting down because you need to call an attorney.
Yes.
And I'm going to stop discovering things and let
Right.
the attorney start discovering you might need some protection here. It was a mess. So then we called you.
Yes. Yes.
And I think that the real issues that started to occur to me as I dug in were, first of all, there was no governance structure. They had never met. There was no committee. They had never met. I don't think anybody was, had even thought about, is our definition of compensation correct, or things like that. There was no delegation of authority anywhere. And there were investment professionals. Well, I guess they were thought of as professionals, but there were investment people who were, I'm going to literally say, impersonating a fiduciary, right?
That's probably
because they really weren't fiduciaries.
Yes.
So that's where we were. It was, and just going at this from the fixer-upper theme, good grief, there was, it's like the plumbing was bad, the electrical system was bad, the foundation had cracks in it, and there was water coming out down the walls.
Well, and I think the house here on the slide, it does a pretty good job.
Well, I think you're right. Yeah, I think it does. So maybe we'll go to the next slide.
So digging into all of those were foundational, fundamental problems in the retirement plan. We're going to start with the definition of compensation. And there are a litany of compliance issues and administrative issues in a plan. We're not going to address all of those today, but we're going to talk about a few that applied here and that we see on a regular basis causing problems and causing real structural foundational problems in a retirement plan. And the challenge with the definition of compensation is in a retirement plan, compensation is used for a variety of different purposes. Elective deferrals, the code section 401A-17 compensation limits, non-discrimination testing, and then is the plan top heavy? We're determining whether the plan is top heavy. Within the definition of compensation, if you look in the Internal Revenue Code, there are 3-4 definitions of compensation, and there are variations within those definitions. So it gets complicated fast. And so what we advise plan sponsors is every year, make sure at least annually that you're reviewing your definition of compensation. We see this a lot when there is transition in those who are responsible for administering the retirement plan. We had a client down in Florida who called us, CFO had just joined the company and said, we've been looking at elective deferrals and employer match, and we discovered that bonuses were supposed to be included and were not. And this has been going on since 2009.
You know, and Tyler, I think that's one of the really practical but big things that occurs is you have a change in personnel, and a person may not be a professional retirement plan administrator, right? Most likely isn't, but they've done the administration at a previous employer, and so they come in and they do it the way they've always done it, and right there, it may not meet what the plan document says.
Yes.
And so all of a sudden, unknowingly, you start creating this huge mess that has to eventually get corrected.
Absolutely. So as a plan sponsor, it's important to understand what your definition of compensation is. And it's a challenge too, because you look at your adoption agreement, it may say W-2 wages, 3121 wages. What does that mean? What's included? Making sure that you as an employer understand what the definition of compensation, the different purposes, and what the definition of compensation for that purpose means.
So, you know, once you've understood what the big issues are, at least that's what we did here, is we sat down and walked through with this committee, you know, who's a fiduciary. I will never forget you and I sitting there with the head of their board, and he had no idea that he was a fiduciary and was just livid.
Uh-huh.
And, you know, I think that when you start digging into what do we have here? So who's the named fiduciary of the plan? Who's the plan administrator? This particular scenario, the plan document was wonderfully drafted and had all kinds of flexibility in it to remove the fiduciary liability from the board and then delegate it to a committee. And, you know, all of that was in there in the plan document. But the adoption agreement that was used just checked the box, said it's, you know, named fiduciary is the plan sponsor, and everything was default.
Uh-huh.
And I don't know that that's what they meant to do. It's a big issue. And then to top it off, we had, as I mentioned earlier, we had investment professionals in the plan that were not representing the plan. There was no contract. They were getting paid by a third party. That wasn't disclosed in any public documents. It was just a mess.
Yeah, and going back to the point of being a fiduciary, who is a fiduciary? And we often find plan sponsors are confused or don't fully understand the definition, the breadth and the depth of the reach of an ERISA fiduciary. Obviously named in the plan, you're a fiduciary, plan administrator, ERISA 338 investment manager. But then there's this catch-all definition: anyone with discretionary authority over plan administration or assets. And the Department of Labor in situations where there are breaches and where there are egregious situations as well. But they will pull in anyone within that scope, anyone within that definition. We see this also in fiduciary breach cases. And so it's important that if you're involved tangentially, even with the retirement plan, you are likely going to be considered a fiduciary. What are your responsibilities as an ERISA fiduciary? Firstly, it is to operate the plan for the exclusive benefit of participants and beneficiaries. And then we look at the prudent expert rule. And this one is especially challenging because if you're a layperson on a committee and you don't necessarily have an expertise, courts and judges have not found as favorable to individual fiduciaries the excuse that, well, that just wasn't my area of expertise. The direction is that if you're not an expert, then you need to bring the expertise that you need in from an outside party to make sure that prudent and wise decisions are made.
There's no "I'm stupid" defense.
Correct.
Here.
Correct.
I mean, I know that in some states there are "I'm stupid" defenses for like automobile insurance policies and such, but not for ERISA.
Yes.
Doesn't look good.
So you are held to, as a retirement plan committee member or fiduciary, you are held to the standard of someone who with expertise would make the same decision. So if you don't have the expertise, bring in outside experts, legal counsel, investment managers or investment advisors, whatever expertise that you need to make sure that the decisions are held to that prudent expertise.
So, I often hear from people when they discover that there's an issue, that, oh my gosh, now I'm going to get sued or whatever. But as a plan fiduciary, when you make the discovery, and I'm asking the question here, when you make the discovery, if you start to take action to remedy the issue, how at risk are you really?
Well, it depends on what decisions have been made thus far. And I guess, so assuming that that you bring in an expert, you realize that you've got an issue that you just don't have the expertise on the committee to handle, and you address that immediately. I think there's the risk is substantially reduced. I mean, if decisions have been made already that required an expertise and they've been made by those who don't have that expertise, I think there's more risk, there's more exposure.
So for administrative issues, there's normally ways that you just using the regulations remedy the situation. There's a remedy for most administrative issues, like the definition of comp. It may cost you something.
That's right. That's
right.
Yes, there are remedies. Yes, that again, you want to make sure at implementation upfront that you avoid and mitigate exposure to these issues. But if you have these issues, yes, there are correction programs for instance, definition of compensation.
What do you think about this particular situation that we were in, where you had an investment professional who, and I use that term loosely in this case, that you had an investment professional that was not serving the plan?
Mm-hmm.
And what kind of risk continues? Are they still at risk, even though they made all kinds of wonderful changes eventually?
Obviously, again, at implementation of the plan, you want to get it right. But if you've already made decisions with individuals that where it would be difficult to satisfy the prudent expert standard, then the best advice is to address it immediately, right? And to address those issues and pull in the right advisors and experts and counsel, and then clean up what you can, right? And mitigate that exposure retrospectively, but then certainly get a process and a procedure going forward. And I anticipate that a lot of plan sponsors are in that situation.
They are. There's a lot of them. And it's not just small plans.
It's
right?
not.
It's across the board.
It runs the gamut,
Mm-hmm.
right? Different industries, different plan sizes. So again, the ERISA fiduciary statutory duties, very important. Diversification. Al, as a former investment advisor, investment manager, what are your thoughts on
Well,
those?
I think that it's common to look at what are my fees and what's the performance of a fund. And in general, there's not a lot of discussion about risk. And you need to look at the whole picture. It's one of the reasons we started Verify Analytics, is to look at actual plan outcomes, measure how things have happened on a risk adjusted basis, because the optic is very different when you introduce risk. These are long-term investments. And we've had this conversation before, but 401k math is bad math.
Right.
If you have $100 and the market goes down 25%, you now got $75 of value. Well, so that's a 25% drop. But in order to get back to $100, you need $25. Well, that's 33% of the $75. So you got a 25% loss, you need a 33% gain just to get back to even. And so if you can reduce that loss to 12.5 by having some sort of risk mitigation in place, then it's a far lighter lift.
Absolutely.
To get not just back to where you were, but past it, because growth is a big component of all 401k and 403b plans.
So you want to have diversified with respect to risk, not just fees, and it's not just a focus on fees, but it's risk. It's a multi-dimensional analysis.
Right. People tend to allocate they allocate a lot of focus on the Morningstar style box, and if I've got funds in every different box, I'm good. And I'm not going to say that's an awful way to go, because it's better than nothing, but you can have all 9 of those boxes act the same way. So the market goes down, all 9 are going down the same way, unless you are careful in how you design your investment lineup. And so diversification is something that requires a little bit more than a style box analysis.
Great point. Adherence to the plan, that seems rudimentary and very fundamental, but it is absolutely a pitfall that we see a lot of plan sponsors fall into. And again, it is so important that as a plan sponsor, as a decision maker for a retirement plan, that you know what the plan says.
That's the answer to every plan question.
Yeah.
What does the document say?
That's right. And then your disclosure obligation. So as a retirement plan fiduciary, ERISA has specific disclosure obligations, SPD, summary plan descriptions, Form 5500 filings, making sure that the plan is adhering to those DOL requirements.
Yeah, just one item there, because if you're new to this world, the disclosure regulations changed for participant disclosures in 2012. And prior to that, I often think of it as, the disclosure rules were like a barking dog behind the door, but it's really just a speaker with the sound of a barking dog. And now the rules are it's really the Doberman, right? Because you can lose if you don't disclose properly, or if you make big mistakes or or wrong statements. You can lose your 401k safe harbor.
404C.
Yeah, 404C. So that means if somebody invests 100% of their money at age 62 in the new Bitcoin fund and loses it, if you don't have 404C protection, that's your responsibility.
Great.
So that's an issue anyway. So then to design the plan, to go to putting the house back together, you really want to walk the, who's the named fiduciary for administration and investments? How do we avoid the board being brought in? Is the adoption agreement filled out correctly? You want to have that done correctly. That's a big deal, because the adoption agreement drives most of these prototype documents. The adoption agreement's a really important document.
And I would just add, not just correctly and making sure that you understand what you're selecting and electing and what the implications are, and does this truly match what your objectives are for your retirement plan.
And then you need to know how to operate, right? And that therein lies the need for a committee charter.
We'll talk about that in more detail in a later slide.
And then the board resolution, because the board, if the board wants to not be responsible, they need to delegate that authority in some fashion. And unless that is designated in the plan document, right? There needs to be a board resolution. And I know from doing plan assessments that I ask for that, and I get the silent, I don't know. I'm sure it's there somewhere.
Right.
So, we talked about board of directors being implicated. No board, you don't want your board to be deposed for what's happening with the 401k plan. They shouldn't be paying attention to that. They have other things that are far more important to the business than the 401k plan. They need to be informed, I think, but especially when you're dealing with not-for-profits or these private universities. The board of trustees is where the deep pocket is. So if there's a lawsuit, they've got the board of trustees in a public institution has a lot of risk associated with a retirement plan. And now we're starting to see the early big institutions being sued for breach of duty, and that's that most likely there'll be copycats,
Right.
and they'll come downstream a little bit, and there will be issues there. And I think it's the same thing with the new DOL fiduciary rule. What if you have an investment professional that's not a fiduciary? We certainly had that in this plan.
Yes.
There was no document defining any of their duties, and that's a common thing. Even if there's an agreement that says we are a 321 fiduciary, I've seen some of the new best interest contracts, and they have a clause in the paragraph that basically says if the DOL fiduciary rule goes away or is delayed or anything, this contract is, or these provisions are null and void. And so it's important for any of you plan sponsors that are on this call to understand, if you have one of these where your advisor has a best interest contract, you need to read that clause, because the rule's been delayed till July 2019, and who knows what will happen between now and then. That's a big deal, because you might think you have a fiduciary supporting you, but you don't.
Absolutely. But a major issue here was in this matter, no plan committee, no periodic meetings. That's a problem. That's a problem.
Yeah.
And no documentation to support investment changes. That's a problem.
That's why I called you.
Yes. Yes. So let's dive into a retirement plan committee. We'll talk about the committee charter in a later slide, but the retirement plan committee, what does that look like? So the board of directors generally responsible for fiduciary obligations. Al alluded to this earlier, but the board can delegate this responsibility to a retirement plan committee. But the board needs to be careful in the selection of these committee members, and there needs to be a mechanism for periodic reporting of what is the committee doing, what responsibilities and what decisions are being made, and the board still needs to have oversight of the committee.
So I have a question for you there. If the plan committee is designated in the plan document as responsible for the plan, does the board have as much liability as they might if they delegated to a plan committee? Or is it
I think
less?
it's less. I think it's certainly less liability, but I still think in egregious fiduciary breach situations, fiduciary liability situations, everyone tangentially related can be pulled in.
So you should have some indicators to at least show the board that, look, we're operating properly and we're getting value here. And
Absolutely.
And
Absolutely.
we've looked at it. Okay.
Yes. With respect to the compensation or the composition of the committee, it is critical that the members of the committee understand and respect the ERISA fiduciary principles. We advise that plan sponsors get the fiduciaries, the retirement plan committee members, to sign a document with an acknowledgement that they are an ERISA fiduciary and what that means, so that it's very clear.
That's where you see fear on the faces.
Yeah.
And until they start to really understand
Yes.
that they're operating properly, there's like, do I really have to be on this committee?
That's right.
Who can get me off of here?
Yes. So yeah, again, we advise that committee members acknowledge their status in writing. And just to note, the term of appointment for the retirement plan committee member should contemplate that it's long enough for continuity of plan oversight, so that you're not constantly, it's not a revolving door of retirement plan committee members being appointed and rolling off the board.
So what's a good term?
And it depends client to client. We always have that conversation. I think generally you want someone on for at least 2 years. I think that's probably on the low end. But people do leave employers and roll off committees. So again, that's just something to contemplate. You want to think about the composition of the committee and making sure that the terms are long enough so that there's continuity. Mm-hmm. You also want to make sure that there is a broad representation across different sectors with respect to committee members. So human resources, finance, business affairs, legal departments with a caveat.
Yeah, so I think there are many general counsels that I've run into when I was working as an investment fiduciary to plans, and they were committee members. And our first job would be to kick them off and make them an interested party, because they have a conflict of interest. They owe their duty to the employer first. Same is no different than, if you have the CFO or there's company stock in the plan. It's an issue. And they were always very happy to go, oh, okay, I'll be an interested party, because they get it, right?
Uh-huh.
They get it.
What is your thought, Al, with respect to, and we get these questions, more of a layperson being on the committee versus a shop foreman?
Yeah, so I understand why you might, politically in the organization, you might want to have the shop foreman. Now, if they happen to be really bright and an investment guru, maybe it's okay. But the test, I think, is, okay, take the person, put them in a deposition, and as the committee chair or whatever, are you comfortable with them answering the questions that will be asked? And if you are, fine. But if you're worried about them saying, well, I don't know, I'm just, we get free food, if that's a bad answer, right?
I mean, I would say they have to be buttressed with these other representatives from these different sectors.
Right.
Human resources, finance, business affairs. So yes, buttressed with other experts in respective areas.
If they're solely there to bring the information from the shop floor, here's what people think, I think that's different. But if they're on the committee, maybe they're an interested party, as opposed to a committee member. So they have influence, but they're not a voting member. I'd feel more comfortable with that. Agreed.
With respect to structure and size of the retirement plan committee, it really depends upon the size and complexity of the plan and your ERISA legal counsel. You should be working with the ERISA legal counsel to think about the composition of the committee and who makes sense for that particular committee, for that particular plan, for that particular business. Larger plans, obviously, larger, more complex committees.
So in terms of this organization that we've been talking about, they've ended up with, I believe, 3 committee members, And it's because it wasn't a huge organization, but
Right.
you have someone in essence from the executive team, someone from HR, and someone from finance, and that's
Right.
how they built it.
Right.
I thought that was excellent.
Yes.
That's where they ended up.
Yeah, that's a good composition. As a foundation to the retirement plan committee, you need a roadmap. The committee charter should provide a foundation for the establishment, ongoing governance, allocation of fiduciary responsibilities, the retirement plan committee's structure and their objectives and responsibilities.
This is the blueprint to rebuild a house, right?
Absolutely.
You know, it's the architect's plans to make sure that we're going to build what we set out to build.
Yes, and sets forth the fiduciary objectives consistent with the ERISA guiding principles. So the committee charter is the roadmap for the retirement plan committee, foundational part of retirement plan governance and critical for setting up that good, when you think about tearing down a home and rebuilding, this is very important.
You know, I have seen some great committee charters that get really detailed. Like, you know, we're going to meet, it's just an overstatement, but we're going to meet on the third Thursday of every quarter and discuss this from 2 to 4 o'clock. You know, and I think that you know, going overboard on things where you could be more broad and say there's an intention to meet quarterly, but we'll meet no less than semi-annually, and to discuss the items, that sort of thing. You know, in drafting a committee charter, I think you need some flexibility.
Absolutely, Alan, you make a great point. You don't want your governing documents to work against you, right?
Right.
And if you become so specific and so rigid in the establishment of the committee charter and the retirement plan committee, then you're much more likely to run afoul of these documents. And these documents are supposed to buttress your fiduciary liability risk mitigation, not to create more exposure and create more liability. Again, this is why it's so important to work with ERISA legal counsel at implementation of the committee charter and the setup of the retirement plan committee. Documentation of plan committee decisions, very important. Each plan committee meeting should be documented, and then those minutes should be approved and reviewed by legal counsel. We generally recommend that meeting minutes be retained for at least 7 years. I would say probably as a best practice, keep them longer. There's really no need to only keep them for 7 years, but that's just a basic kind of threshold time period.
You know, with committee minutes, I think that because people get focused on documenting what happened, there's a desire sometimes to put in the he said, she said, you know, Billy liked it, Julie didn't, that sort of thing. This is my personal preference, but the committee minutes should have, okay, here's the agenda. Here are the items we discussed. Here's the decisions we made, period. All of the wonderful discussion and what people thought is just fodder for a plaintiff's attorney if it ever becomes discovered.
Absolutely, Al, and it goes back again to what we had discussed earlier with the committee charter and the retirement plan committee charter. If you over provide information, you certainly don't want these best practices to then be working against you as a plan sponsor. So it's very important that your decisions and documenting those decisions through the committee meetings are to the point and don't provide latitude or red flags for then issues to be discovered, or for a plaintiff's attorney to come in and say, this wasn't a best practice. So yes, so you want to stick to memorializing that you're complying with your committee charter, your retirement plan committee purpose and objectives, and your investment policy statement.
Right. And there is a tension that exists between writing something properly in the minutes from a legal perspective and from an investment or administrative perspective. I think that's why it's always good to have a legal review of the minutes. Because certainly, you're trying to administer the plan right and do the things right from an investment perspective, but you do need to have the legal understanding to memorialize that document.
Absolutely. We're always looking for red flags. What would create more of a problem in this memorialization, because we want to buttress the mitigation, fiduciary breach, fiduciary liability,
Right.
and again have these documents working for us, for our plan sponsors. Diligent documentation just would also add can be used as evidentiary of prudent fiduciary practices. So documenting retirement plan committee decisions and doing that well is a great practice for designing thoughtfully your retirement plan and designing it to mitigate fiduciary exposure.
Mm-hmm. So we've talked about delegation to the plan committee and having a board resolution, a committee charter. I think those are just absolutely necessary, right? This is not a what if, but I think there's a lot of questions around, especially because of the DOL fiduciary rule, around can I really eliminate fiduciary liability? So if I have a 321 investment advisor, which people call a co-fiduciary, what you're bringing in is hopefully expertise, which is going to reduce your risk. You're also bringing in maybe another insurance policy, but you're not really mitigating your risk in any other way. It's not like they have half the risk, you have half the risk. You both have all the risk. Is that fair from your perspective?
That's right. That's right. And I think there's a misconception of that. I think there's a misconception.
Right. Like I'm reducing my risk.
That's right.
Because the investment committee members are 321s.
Right.
They may not know that, but they are. But if you bring in a 338 investment manager, they now have discretion over investment decisions. So that responsibility does lie with them. Now you still have to monitor. You have to have oversight. So you want to make sure they're not doing anything stupid. But I think you have reduced your investment fiduciary liability when you hire either a 338 investment manager or a 402A named investment fiduciary. I think the same thing. We don't have it up on the screen, but if you have a 402A named fiduciary to oversee the plan, I think you have significantly reduced your liability as a plan sponsor with your whoever is in the oversight chair.
Right. And typically the fees are higher for a 338 or a 402A because they're taking on more responsibility, more risk.
And they should be higher.
Yeah.
Right.
316 named administrative fiduciary, very important and can be very helpful for plan maintenance and plan operation. Just a note, the 316 named administrative fiduciary does not supplant the need for an investment, a 321 or a 338 investment advisor, investment manager, or an attorney, legal counsel to review retirement plan governance and review documentation. The 316 is a separate responsibility, separate tasks that they're
I think that because there's such a prolific new number of 316s in the marketplace, you really have to do your due diligence on what responsibilities are they actually taking.
It's a great point. We get a lot of service provider agreements, and we read through these, and we always have plan sponsors who are ultimately disappointed because they thought they were getting something that the contract, the service provider agreement says, no, that's not our responsibility. That's yours, plan sponsor. So we always encourage when you're signing up with before you sign up with a 316 or a service provider, that you make sure and review with the legal counsel what that document says and what responsibilities they're taking on and what they're not taking on.
Yeah, especially because it's a newer area of distribution of services, right? So I think that you'd want to have a closer eye on those documents, because there's just a lack of less understanding about that than even in the investment world
Absolutely.
today.
So add-on and additions and improvements, we think of these with respect to a retirement plan, automatic contribution arrangements. We know statistics show us that generally 70 to 90% of participants who are with an employer that adopts an automatic contribution arrangement, they will not opt out of that. So they will continue to automatically contribute to the plan and will not opt out of that. And that's a great way to increase plan participation and increase essentially then plan the size of the plan and the money going into the plan. Another way to optimize plan design is to add an employer match. And then one situation we encountered with a client, they had a year waiting period for the profit sharing contribution and the elective deferrals. And so we told them, listen, take out the 1 year wait, the 1 year eligibility requirement for the elective deferrals. You can leave that in for the profit sharing contribution, but a 1 year wait, and then they only had 2 entry dates during the plan year. So someone could start in July and not be eligible to participate until the year and a half later, December after following that July. And so we encourage our plan sponsors to provide for in the plan immediate eligibility to participate with respect to elective deferrals. And then regular educational meetings so that participants are aware of the features of the plan investments, and constantly this is a top of mind issue.
So one of the things that when you get to actually fixing the plan, and this was true in this situation that we were working on, the question becomes, what do we do first, right? And so if we were going to hire an investment professional, a record keeper, and a 316 plan administrator, who's first?
I would generally say the 316 plan administrator to work on the operational details and administrative details. And so I think that's a good foundational first place to start.
Yeah. And then I would say that the investment professional should be next, because obviously I'm a little bit biased here, but I think that you want to design the fund lineup that you want, and then you want to make sure that you have a record-keeping platform that supports it. But you don't want the record-keeping platform to drive your investment lineup. Now you could also, so one thing that is possible in the marketplace is you can have a record keeper that also will say they'll act as a 316 plan administrator. And so, that's something you've got to take into account. I think if that were the case, I might say go the investment professional first. Mm-hmm. Just because it's so important not to get stuck into a set of investments that you didn't want.
Right.
And it's fairly common.
And just as a last point on this slide, I would say that just a reminder that retirement plan fiduciary compliance is not a one and done. It is an ongoing, it's a moving target. It's an ongoing responsibility. And so you want to have a ERISA counsel to guide you through these important decisions that are made throughout the year, each year in a retirement plan, and to mitigate your exposure to fiduciary liability.
So in terms of what they did, obviously they started out with a plan assessment, and that, from going back to the house analogy, they found out that they had a mess.
Yes.
And that's where I think you go right to strong ERISA counsel to get this going, and then look for, as we just discussed, an RFP for 316, RFP for investment professional, and many investment professionals will do the RFP for record keeper, and so that's a good process. And you just want to make sure that if you're going to do an RFP, you want to do it in a way that it's independent, it's unconflicted, And that should be obvious if you've gone through this whole process. You don't want to end up with a conflict by design after you've gone through everything we just talked about.
Right.
So you want to talk about what they did?
Yeah. So in this example, the plan committee, we named them in the signed plan document to buttress and to protect the board.
So they didn't need a resolution. They're designated in the plan document, which I think is just absolute best practice.
Yes. Development of a committee charter with details about the retirement plan structure and their duties. 316 oversight of plan operations as a named fiduciary engagement for this client. And then a designation of a 338 investment manager for the plan who took on the risk of the investment decisions. And then constant and consistent measurement of plan outcomes through your services. Right.
Yeah.
And then the idea was that we were giving them tools and options for supporting participant decisions and participation.
Right. Yeah. In this case, they were doing regentrification.
Yes.
Right. I mean, they were taking a dilapidated building and turned it into a beautiful new home.
Yes.
Is what they did.
A complete makeover.
Complete. Right? Yes. And one of the things I would say, just because we really haven't spent much time talking about investment policy statements here, the investment manager that was chosen was able to bring a really strong investment policy statement to the table, which I believe you reviewed.
We did.
And so they have the ability to measure and monitor according to the statement that they're bringing to the table. That's something that can happen if you get somebody outside to write the investment policy. The investment manager might not be able to meet what's been written. And so I certainly think that you'd want them to bring it to the table, not the record keeper, not some other third party. You want that organization to bring the investment policy statement to the table. I think that was that just shored up, it was the granite countertops or whatever you want to say, that just made things, it was a beautiful end design.
Absolutely. And I think we worked in tandem with the investment manager to shore up that investment policy statement. And I think we've got a really good working document.
Right. Okay. I think that's it. We're ready for any questions that might be there.
Ellen, Ann, nice job. And again, to our registrants, please feel free to submit any questions during this time. We'll take about 5 or 10 minutes to answer any questions. And you guys covered a lot of land here, but are there some common retirement plan committee problems that maybe we didn't talk about that you'd like to touch on and what the implications are?
There are a litany. So where do we start? One of the most common issues that we see is that there's not communication between the retirement plan committee and the board. And the board delegates or delegates this responsibility, but then really does not follow up with the committee to monitor the committee and make sure that that it is running smoothly. It doesn't oversee the committee. So we recommend that the committee and the board put in place a process, a procedure for regular communication. That's one of the first breakdowns that we see in the retirement plan committee. We also see retirement plan committees fail to properly or fully utilize their plan advisor and their other experts. And they have them, they've engaged them, and they don't necessarily reach out to them when critical decisions are being made. And so they underutilize the resources that they have available to them. Big issue for retirement plan committee breakdown in our world is not keeping up track of required plan amendments. The IRS releases a cumulative list every year, and this is a must on every year's calendar for a retirement plan committees to discuss the amendments that are required by law to be made to the plan. This is again why ongoing ERISA counsel is so important for a retirement plan committee. Then we just see disorganization within the retirement plan committee. Not enough staff work is done before the meeting, and so the meeting consists of a discussion that should have been had prior to the meeting, so that the meeting is focused on making decisions and optimizing the time spent in the actual retirement plan committee meeting.
Thank you, Ann, very much. Al, with your experience, not only as a plan fiduciary, but in many conversations you have in the market, how can plan fiduciaries simplify the process of exploring for bad facts and eliminating them?
Well, I think that just, this is going to sound self-serving, but I think just a plan assessment periodically is, get an expert in to identify the issues. It's no different than a home inspection, right? You just want someone to take a look with an independent eye and identify any issues in case you have a big one, right? And once you've done that, then you find out or figure out how to mitigate it. And I think that there's also tools. If you're measuring plan outcomes and you're looking at actual value added, it kind of becomes obvious if value hasn't been added. You want to now dig in and say why, right? And that's certainly what we're trying to do at Verify Analytics, is to help plan sponsors identify where the issues are.
Yeah, so it goes in line with, Dan, what you talk about, ongoing ERISA counsel. This is a part of the rehab and just making sure you're checking in and seeing if the plan's okay, and preventing some of the major problems that can evolve.
Right.
And why is it important? And you guys have touched on this. Why is it important to bring in experts outside in addition to the retirement plan committee members?
It is important because it's evidentiary of a good process, a good practice, and retirement plan committee members are held to standards. And most of us have expertise in certain areas, but we're not experts in every area. And so the retirement plan committee should be diverse and comprised of a lot of different areas of expertise. Now, for a smaller plan, and we mentioned this for the client that Al and I worked on together, 3 committee members may be enough. But if you're a larger plan, you may need 10. Again, this is part of the composition discussion that should take place in a contemplation of what makes sense for this retirement plan size and the retirement plan composition.
Thank you.
We have another question here that's just come in from our audience, and I'd like the panel to take a gander at this for us, and if it's something that we don't have enough time to go into in detail, we can certainly get back to you. But the question is, I find the 1,000-hour eligibility rule for otherwise part-time employees as an occasional problem. If an employee begins the year with an anticipated 800 hours, and for some reason has hours added toward the end of the year, pushing them over 1,000 hours, my interpretation is I have to look back to the beginning of the year, in our case, January 1, and calculate back contributions along with lost earnings and lost opportunity. Is there a way to avoid this?
That's a great question. I think that is probably it is a common issue for plan sponsors, and it is important to stay aware and on top of part-time employees, and I say that in quotes, part-time employees, which means a lot of different things. In the health and welfare benefits arena, it's a different hour threshold, and so it's important to monitor these part-time employees. And firstly, I would just say that the plan document needs to reference the number of hours that someone works as being as the threshold for eligibility or ineligibility. So for instance, I want to say any employee that works 1,000 hours or more is eligible for the plan. We've seen this happen with retirement plans where they say part-time employees are not eligible. That's a problem. Part-time employee, as has just been described here in this question, a part-time employee can transition. They can work longer hours during certain periods and very easily go over that 1,000 hour threshold. So the first step is in your plan document, you want to make sure that it defines eligibility in terms of hours, not in terms of what you think is a part-time employee or a part-time employee. Even if you've defined that, it needs to be 1,000 hours needs to be the threshold.
You also need to make the administrative system has the ability to track hours.
Absolutely.
I mean, at the plan administrator, record keeper, custodian level, if they're tracking, something else, like, if you're at work one day, you worked a month.
Right.
It's a whole different result here.
Right.
Potentially.
Yes. And there are equivalency issues with the Department of Labor regulations as to hours of service and how those are counted. I think that's a whole separate issue though that can create a problem. But I think the key here is to have a process and a monitoring of this status so that those who are that are similarly situated, you'll have a better predictor of whether they're probably going to pass over that threshold. It is a challenge because as soon as they hit that 1,000 hour threshold, it is a process of retroactively then going back and making sure that they are accommodated as being eligible for the plan and eligible for elective deferrals and match and all the things that go along with that. Firstly, you want to make sure that it's described correctly in the plan document. Secondly, you want to have a process for monitoring those types of I'll say variable hour employees that could potentially cross over the threshold and work with counsel to develop a process for monitoring those employees so that you can easily make that transition once they hit that 1,000 hour threshold.
Thank you, Ann. I want to give Al and Ann both a chance to leave some final thoughts. And Al, kind of a question to start with. I mean, why is it important for committees and their advisors to focus on plan outcomes instead of just fees? And any other final thoughts you have?
Yeah. So, your duty is to make sure that the plan is run for the benefit of the participants. That's the duty. And so if you're not measuring what's happened, if you're relying on we have lowest fees, therefore everything's okay, that's an assumption, right? And I think that assumptions don't always lead to good outcomes. But if you measure the outcomes, then you can understand where things are going right and where things are not. And so measuring outcomes, I think personally, I think it's just critical to running a plan well and meeting your fiduciary duty.
Thank you. Any final thoughts?
Yeah, so I think we went over a variety of different issues in a case study and what not to do. But I think it is important, even if you don't have all of these processes in place, that it's not too late. And you can put these in place with advice and experts and do that in a much easier posture than if you're in a situation where you're doing cleanup. You've been in an audit, IRS, Department of Labor has caught these issues, or a participant has filed a complaint or hopefully not, but a fiduciary breach lawsuit. And so it's better to address these, even if you don't have your whole home, your retirement plan renovated. You can take it piece by piece and work through these issues, but it's better to do this on a proactive basis than to wait until the wall caves in or the
Right.
Ceiling caves in, and then it's a much more expensive and time-consuming endeavor. And so this really is about a cautionary tale of putting in place best practices before there's a major compliance issue, a major problem.
Well, thank you, Alan. Thank you, Ann.
Thank you. Thanks for having me.
And to all our registrants, we really appreciate you spending the last hour with us. If there's any final questions coming up, you have Al and Ann's emails on there. We'd also love to hear from you. If there's things that you'd like to hear about in future webinars, please email us back after you get the copy of this webinar. Thank you all very much and have a great day.